good morning on this 22nd day of April 2020. Time now for the McIntyre Elder Law Report. Good morning, Greg and crew.
Good morning, Milton.
Good morning.
Thank you so much, Milton. I appreciate it. Feel lucky to be here today, to be out and about. And to all you guys at home, guys and gals at home or in your cars or wherever you are, thank you for listening today. We've got a special treat for you today. We are going to perform, and it's like a performance, a live, free, I ain't charging you for this, full-on estate planning seminar. A live, free, full-on estate planning seminar. And we have our seminar team here, which consists of myself, Greg McIntyre, elder law attorney.
Brenton Begley, also elder law attorney.
And the
Hayden Soloway, not an elder law attorney,
but professional audience member today.
Right, and you have the in front of your name too. So
I know.
Means you're important.
If you have any questions
notorious.
for us today during this seminar, if you have any questions, please give us a call at the radio station. Talk to Milton. Milton will get you into us. Milton's our engineer running the studio, obviously. The Milton. Milton, what's the number here? 704-435.
That'd be 704-435-2844 or 482-1390 or 735-8071.
So any of those phone numbers, okay? Give us a call. Give us a call here at the radio station, and we'd be glad to field your questions. Otherwise, Hayden, you have a number of questions that you would like answered during our seminar today, don't you?
Yes. You did ask me to prepare some. I've done a lot of seminars with you.
Right.
And so some of these might be less general. So the people there, if you want to get a pencil and a piece of paper and make some notes about questions you want to ask, you'll have an opportunity to do that, hopefully. And I'll ask some of the questions that I tried my best to think of that maybe wouldn't come up until after the show is over.
Sure.
Oh, why didn't I
The
ask
frequently asked questions at
that? The
any
unfrequently
seminar.
ones.
And if
are
you
the
want to
ones
see the
that-
PowerPoint slides that go along with this, the graphics that go along with this, and you want to see us on the radio, go to KTC Broadcasting's Facebook page. We're live there. We've got the slides up, and you can see us on the mic, emceeing.
live.
Okay?
in
Live.
person.
That's right.
Right.
That's right. So without further ado, we're going to get into it. This seminar is brought to you by McIntyre Elder Law. If we are offering free consults as a bonus for being here and listening to our seminar today, thank you for being here. Free consults. You can take advantage of your free consult for estate planning and elder law and get your affairs in order by calling McIntyre Elder Law at 704-749-9244. That's 704-749-9244. Just dial 1704, please. 749-9244, or visiting us online at mcelderlaw.com/estate planning. Okay? So, this is our Are You Ready Estate Planning Seminar. And, man, you know, when I went down this path a long time ago of just doing estate planning and elder law, I said, you know, the McIntyre Law Firm, that really doesn't scream estate planning and elder law. Plus, I'm a sappy guy. I will take your case to do anything for nothing, generally. Like, that was my mentality, especially at the time. So you could convince me to do a speeding ticket, even though I was concentrating only on estate planning and elder law. And when I got out here and did these other things, it took a ton of time because our firm wasn't built to do that. So I named our firm McIntyre Elder Law, which elder law is a specific kind of niche. Is it niche or niche?
Niche.
Both.
Niche.
Both.
It's both. It's both. It's niche. What's a niche? Ain't nobody say no niche.
It's
All right.
like a notch on the end.
A notch. Okay. So it's an area. It's a sect. It's a cult of elder law. I mean, of estate planning. Okay.
We're really getting off the rails
That's right.
today.
It's a small part of estate planning. And when I started out, you know, was working with this marketing person. They said nobody's going to know what an elder law is. You know, I said, okay, well, we need to tell them. I'm going to name the firm McIntyre Elder Law. And even some people might be offended by that. Are you offended by that, Hayden? Am I offended by? I don't know.
No.
Elder law? Yeah, I'm not. But my mom was. My mom said, Greg, my mother said that, right? But at least at the end of the day, you know exactly what I do. I help seniors protect their assets and legacies. And still, even though we named the firm McIntyre Elder Law, people come in and ask me who my partner, Mr. Elder, is all the time. Or if I'm Mr. Elder, with a straight face, as serious as they can be, right? So no, I am not Mr. Elder Law. I'm McIntyre, and we have an elder law firm, and that's all we do. And it's also as much to send a signal to people as to remind me and the people in our firm that that's only the cases we take. That's only the cases we take. Okay?
Right.
So, helping people. There used to be a different slide here. We have the coronavirus up right now because at the time when I reworked this seminar, I was really thinking about the pandemic and what was going on. And at the beginning of this thing, we were still doing seminars.
Yeah.
Right? And we were really talking about that in our seminars. So, Brenton, what is the coronavirus pandemic, the situation we're in right now? What does that have to do, or how should that speak to people about getting their affairs in order?
Yeah, I think it makes it real. I think you see right now a good example of what we talk about all the time, that you never know what's going to happen. Never know what the future holds, and there's no better example than what has happened with this pandemic. And so when we say, you need to protect yourself, you need to protect your family, you need to protect your assets, because anything could happen. A lot of times it's hard to point at a, really poignant example, even though we all know anything could happen, right? We're not promised. Tomorrow.
Even not in a pandemic.
Yeah.
I could get in a car wreck.
That's right. And so there's analogies. There's personal, individual analogies that we could give that everybody could kind of, relate to. But the thing is this is something that we're all experiencing. And we can absolutely point to that everyone knows what's going on.
Very easily.
Yeah, absolutely.
And I think a lot of seniors, I'm a senior, we have a little fear because we know we're the ones who are vulnerable.
Right.
We know it is a very uncomfortable, to say the least, disease, even if you do recover. So there's fear not only of death, but of going through and possibly having lung damage. But, you can walk across the street and still get killed today.
That's right.
Or paralyzed,
right.
or so.
It's always ever present. But if it takes the coronavirus to let people know that they need to get their affairs in order, so be it. They need to get their affairs in order anyway.
Right.
It's like when, my mom keeps telling me I need to clean my room. When the guests arrive, it's real then. Go upstairs and clean your room, I mean, I need to clean my room anyway, right? And I need to have my house in order, essentially.
Yeah.
And I think this just puts it front and center and smack dab in front of our faces that we do need to have our affairs in order. And there's a number of reasons for that. And we're going to address that. And I'd ask us all, just kind of around the table, to think about some of the things we're going to talk about today: the financial powers of attorney, the healthcare powers of attorney, the living wills, the trust, how those relate to this coronavirus pandemic that we're going through right now, and how that helps people get their affairs in order, and why they need to do it sooner rather than later. So,
right.
So, I've got a slide up right now that's our why, or my why. My why, one, it's my 6 kids and my wife, right? I mean, I love them. I work hard for them. We work hard for our clients on a regular basis. That's one of the things, and I don't care, any job you do, you'll hear people say things like, it's never a job if you love what you do. I don't care what you do. After a while, at 1 o'clock in the morning, when you've been working hard for 5 or 6 days straight, it's a job, okay? And you need to have a why, right? Whether it's digging ditches or being an elder law attorney.
That's right.
So, looking at a picture of my beautiful kids and my wife, my beautiful wife, helps get me through. Thinking about my grandfather, who really lost everything and spent everything to pay for about 14 years of assisted living care. That was a huge deal. I think that's a big why for me as an elder law attorney. And saying, if he would have had someone like me around, we could have, done any number of things. Like for people, for instance, we can save their house. We can save the majority of their retirement and assets, even if they need long-term care. We can help them plan ahead to avoid being in that situation, right?
And wouldn't you love to have that farm where you could take your kids
Sure.
and show them where you worked with your grandfather and how you became his best friend, and just keeping the family? Well, your
Absolutely.
kids might want to live there.
Yes. Yes. And what about you, Brenton? What's your why?
Yeah, you know, I mean, there's a few. I mean, my dad had me when he was 47 years old. He is now 75 years of age.
I want to have more kids. I'm like 45 right now.
Yeah. You still got a couple to go, man.
I do. You
6,
gotta get
that's
past-
weak. You got to pump
I
those
hope,
numbers up.
I hope my wife's listening.
But my dad had me when he's 47 years old. He's now 75, and you know I'm in the unique position where, as my dad and mom are aging, I can help them out because guess what? My grandparents didn't have that ability to plan ahead. Like, well, they did have the ability. They just didn't take the opportunity to because no one told them. Right? They didn't have the benefit of having someone in the family who gone to law school or was an elder law attorney, and not only them, but their friends and other people that I consider just as close to me as family members and were like grandparents to me, have suffered in a number of ways, whether it's exploitation, losing some asset or another, or just having to pay for long-term care, which can be very, very expensive. That put it in perspective for me that something must be done. I don't want to live in a country where you work hard all your life to earn something, and then at the end of your life, you lose it and you can't leave a legacy for your children or your grandchildren. I don't want that to be the country that I live in, and so I want to make a difference. That's my why.
Absolutely. Absolutely. Hayden, what's your why?
My why. I'm going to show you my why. I was trying to find a photograph of my two children, but it's further on in my camera. These are my grandchildren. Could they show up? Let's get a little closer there.
Oh, yeah.
Those are my, and that's several years ago.
Beautiful grandchildren.
But I mean, everything feeds down from the grandparent to the parent to the child, and I want to make sure there are resources. I've got one who graduated from ECU. I've got one who's in the University of Tennessee, and one who's a sophomore in high school. I want to make sure. Hopefully, they don't have student loans. I have a son and his wife who have no children, but they have a love to go camping and do outdoor activities.
And golf.
And I want them to be able to have a good life. And what?
Golf.
Golf.
Yes.
Golf. Yes.
I know.
My kids are great golfers.
I know your son, and he loves to play golf. He's a great golfer.
My daughter.
So is your daughter.
Yes. She can kill it.
Yeah. Great golfer.
Yeah. But Bart and Laura both took after their dad.
Sure.
And they're both very athletic. And my grandchildren, all three of them are too. So, but that's what I want for them. And my sister says you've been trying to die for 20 years, trying to make plans ahead.
Right.
And when I came to work for you, I found out there was a whole big threat here that I didn't know about that
Just
could
trying
have
to
destroyed my plan.
protect things.
Yeah.
And make sure you can help your family.
Mm-hmm.
I think that's awesome.
Yeah, and that's important because, hey, let me ask you, if something were to happen to you, if you were to have to pay for some type of long-term care, God forbid, and you were to lose, all the assets that you've worked for your whole life, would that affect just you?
No.
Right. It's going to affect your children, your grandchildren.
If I have to go into a long-term care facility, it might affect my husband, but I don't think so. I think things are pretty separate. I don't know. That's a subject for another day.
We can talk about it.
But I do know that I have things set up so that my children do receive my assets. If I had not done that, had I not met Greg, and I had become disabled in an automobile accident or dementia or whatever, I can be a little wacky sometimes. I wonder. I could have lost all of this that means more than anything to me to continue a future for my family.
Sure. Thank you, Hayden. I appreciate that. So that's a good way to set the stage, okay? So getting right into it, one of the reasons that we're so adamant in trying to make sure that people have their affairs in order is because we know what may lie ahead. For instance, what percentage of people over the age of 65 right now are going to need some type of long-term care? in-home assisted living or nursing home care. What percentage?
No one can see me, but I'm raising my hand.
Brenton.
People walking on,
All right.
looking online.
All right, so 70% of individuals over the age of 65 will need some type of long-term care in their lives. And I think that number is a bit skewed, too. I think that number is going up, right? Our population is aging.
Sure.
The population of the country is aging. That's just a fact. Right? So that number is steadily rising, but 70%. What if you were, told that you were going to be facing a 70% chance of wrecking driving down Cherryville Highway right here outside, which you might actually have that percentage chance out there. But if you were told that, would you jump on the road right now?
I think that maybe I would go a different direction or choose a different path.
That's right.
Or maybe hang out for a little bit. I'd make some plans. I'd make some different plans.
Right.
Or I'd make plans to avoid that wreck.
Right.
How about that?
Yeah,
That's what I would do.
You're more likely than not to need some type of long-term care. If you have a 70% chance, I mean, that means that you're more likely than not. It's not 51%, it's not 60%, it's 70% or even more.
Sure.
And given that likelihood, that means that you're more likely than not going to have to pay $5, $10, even more, $12,000 a month in long-term care. That's hundreds of thousands of dollars a year.
That's the reason,
just for you.
Yeah, so that's the reason why it's such a big deal. It's because it's so expensive. It's because, it can take what people think is, I've got plenty of money. And it can spin that down rather quickly. So we want to avoid that. And we have ways to avoid that. So we're going to jump in the deep end of the pool here, okay? We'll start with foundational planning. People sometimes come in and they want to talk about all the complicated stuff first.
Yeah.
But they miss the foundational planning. And the foundational planning can mean the difference between losing your assets or being able to protect your assets. And here's why. What's a general durable power of attorney?
Yeah, so general durable power of attorney is when you name someone to act on your behalf as if they were you, all right, for legal and financial purposes.
And a general durable power of attorney is what we would say would be the first foundational document, and you should have that in your estate planning arsenal, right? That's the first thing we should get on the, I've also heard it called a financial power of attorney. Financial power of attorney.
Street name.
This is street name, yeah. So that's an easy way to think about what it does. Is it just appoints an agent to manage your financial affairs if you're unable to manage them. So why is that important? Hayden, why do you think that's important that you have someone else, if you're incompetent or incapacitated because of illness or injury, that someone else has access to financials?
Well, your bills don't stop. Your mortgage doesn't stop. Your insurance on your property, on your car, all these things don't stop just because you become incapacitated. So you need someone to be able to maintain that home in a and make sure that all the arrangements are made to make sure the home is secure, roof, leaks, things like that.
Another one we see all the time that I deal with all the time, and I know you deal with, Greg, is that if you don't have that general durable power of attorney, and you don't have anyone named to act on your behalf, and something happens to you, then how are you going to protect assets?
Why is it called general?
Well, it's general because it covers a general amount of things, right? The general amount of power. So it's more than just finances. It's finances, and that includes all types of finances, whether it's banking institutions, investments, whether it's a safety deposit box, whatever.
Real estate.
Real estate is included in there, absolutely. And
retirement
generally,
accounts, IRAs,
Yeah.
401k, stocks, bonds, annuities, checking, savings accounts.
Yep, and
They
generally
have to be
legal rights
managed.
too. Yeah.
Why is it called durable?
Well, it's durable because it outlasts incompetency, incapacity, or lapse of time.
Does it have to speak to that in the document?
It does. It does. And there's a new statute out, the Uniform Power of Attorney Act, that kind of complicates that a little bit. But what you want, okay, because this is a document that is shown to a third party. So what you want is you want it clearly stated in the document so that anyone looking at it, whether it's a bank, whether it's a 401k company, whether it's a real estate agent or attorney, you want it to be clear that it's a durable power of attorney. That even though something may happen to you and you're incompetent or incapacitated or otherwise unable to act, that person can act on your behalf. Right.
Exactly. So what happens if I become incompetent or incapacitated and I don't have a general durable power of attorney in place that's named? For me, I'll tell you how mine are set up. My wife is my primary. And then if she can't do it because she predeceases me or she is also injured or something happens, then my oldest son comes in as a backup. It's important to have backups if you have those people you can trust, right? Mm-hmm. That way this document lasts for the rest of your life. So if I become incompetent or incapacitated, what happens to my real estate? What happens to my IRAs, my 401ks, any accounts that are just in my name, any investment accounts that are just in my name? Can my wife have any access to any of that at all?
Well, a lot of people think that, your spouse can act on your behalf, right?
Yeah.
You're one person. Well, I always ask people, what's an individual retirement account, right? That's an IRA, right? It's an individual account.
Should be a no-brainer. It's individual.
It's in the name.
It's not a joint account.
Even if you're beneficiary.
It's not individual and your wife or your husband. Yeah.
Even if you're named beneficiary doesn't mean that you can access that account. And so that's a great example. If it's an asset just in your name, that's also an individual asset. And real property, it can be in both spouses' names, but they both have to sign a deed to transfer or otherwise protect that property.
So what if we wanted to put a Ladybird deed on the property or a life estate deed or some kind of protective deed on the property? Could we do that? Could my wife do that for me?
No, she could not just sign for you without power of attorney, or alternatively, she would have to seek guardianship.
Yeah, but in guardianship, can't that be a long, drawn-out court proceeding?
Absolutely, and we want to prevent against that. Guardianship, that's one of the things that we don't want to see. That's a last resort type of thing. You can prevent the need for guardianship by having a power of attorney in place, but guess what? If you don't have a power of attorney in place, you need to protect assets, you need to have someone to act on your behalf. Well, you only have one alternative, otherwise you're stuck. That alternative is guardianship. You have to seek guardianship. It's a court process where you have your loved one adjudicated incompetent by the court. That means they're effectively stripped of all their rights and someone is appointed to make decisions for them. And guess what, Greg, if I were to seek guardianship of my loved one and they are adjudicated incompetent and they do need help, they do need my help, is it guaranteed that I would be appointed as their guardian?
Not at all. So there's no guarantees. And what if there's a competing family member out there that thinks that I'm not going to do a great job as a guardian for my wife, for instance? So therefore, we're in court battling it out with our attorneys as to who should be the guardian. And the courts are very wary when there's conflict within a family to appoint any family member. So in that situation, generally what we see is the court will appoint a third-party guardian, which is not a family member, which is usually an attorney. It's either an attorney or a company that gets paid to be the guardian. That's right. And the family loses any say-so.
How they get paid?
They get paid out of your funds.
That's right.
Out of your money.
Yeah.
There's one guaranteed way. And then, what if we wanted to save and protect some of that money for, say, the healthy spouse or for the family or something, to access a Medicaid benefit to pay for long-term care? There's no guarantee the court's going to agree with your wish to do that.
Yeah, you have to have
They
court
might
approval.
make you spend that money down just on that care or spend that down into the ground. So really putting in place a general durable power of attorney and other estate planning documents is taking control. It's you choosing what happens in case something happens to you. It's not you losing control. It's you actually exercising control. And I'm a big fan of planning ahead.
Oh yeah. General durable power of attorney, probably the most important document you could have. And, that surprises a lot of people because they think the will is probably the most important.
That's what I
document.
get the most. You do wills. You do wills.
That's right.
Larry the Cable Guy.
Yeah.
Yes, we do. However, let's talk about what documents control things during your life, because the will only has power if you pass away.
Right.
Only if you pass away. So, Hayden, you look like you want to ask me a question.
I wanted to ask you one briefly. If you have two attorneys, in fact, can they act independently?
Two agents. Mm-hmm. So if I had, let's say I had two children.
How does that work?
Two children that I dearly love, that I know are going to do a great job for me with financials, and they trust each other and they get along. I might want to appoint them both jointly, but with independent authority to act. Legally, that's called joint and several. Okay? So jointly and severally. They can act together or separately, because one of them might be closer to the bank that day or have the day off. Otherwise, they have to be there and know what each other's doing, which in certain families with multiple children, acting as the agents for mom or dad or both, that might be necessary. You might want all of them to have to agree, and for them to know they're not taking advantage of the money or anything else, right? So they have to all sign off. So those are, what you're getting at is really that it's all on a case-by-case basis. These are very complicated documents that shouldn't be taken or drafted lightly, and that are drafted individually for that person. So, and for that family's and that person's situation. So, thank you, Hayden.
Yeah, you know, and I just kind of follow that up with a general question, because I feel like I get this question in a roundabout way. But I'll phrase it like this: how important is it to have tailor-made documents?
Well, it's extremely important to have tailor-made documents that you have the opportunity to contemplate your wishes and seek the advice of a professional, an attorney, an elder law attorney, an estate planning attorney, right? I mean, when I want my car fixed, you know, when I want my transmission or my clutch replaced, I replaced the clutch about a year ago in my Camaro. I didn't do it in the backyard. I could have, but it would have taken a long time, and there would have probably been some parts rattling around. You see those things like when those movies or whatever else at the end when the guy finishes putting something back together, he's got these extra parts and he's not sure where they came from or where they go. That'd be me, you know. And so now I go to the person who knows how to do it and have him replace my clutch. But I see some do-it-yourselfers out there, and we see people in tough situations because they tried to do it themselves a lot of times.
It's just in general. It doesn't always address all the issues it needs to. Specific issues.
I agree, because you don't know what you don't know.
You know, that's my favorite
That's
saying.
right.
And you provide something with the will to take care of some of those things.
Sure, we can talk about that. So a healthcare power of attorney, we're going to move on. The general durable power of attorney, extremely important foundational document. A healthcare power of attorney is totally separate. A healthcare power of attorney, I bet you can't guess what a healthcare power of attorney does. What does it do?
Yeah. So they act on your behalf, or it allows you to name someone, an agent, to act on your behalf as if they were you for healthcare purposes. Okay, so they can make decisions with regard to procedures, even experimental procedures, if you want them, right? If you want them to be able to, this is all within the scope of what you want. So procedures, medication, pain management, access to medical records, because it's HIPAA compliant,
Sure.
right? Federal law.
I mean, you
HIPAA
need to have
compliant.
the HIPAA section put in there, the HIPAA compliance section. Why might I want to access? Why would I want my agent to have access to my medical records?
Well, for a few reasons, because I mean, ostensibly, it's useful, right? And so, what if they're trying to get you, qualified for some type of long-term care benefit because you need long-term care, right? So, in that way, Medicaid, you got to prove to Medicaid that you have a need. You have to prove to the facility that you have a need, or if it's in-home care, you have to prove to them that you have a need.
I might want to get a second opinion.
Yeah.
Might want to carry the medical records somewhere else to have someone else review them. I might want to check the costs that are being billed by the medical records. I don't know. There might be a malpractice situation,
Right.
where we need to get those documents to a lawyer. there's a number of different reasons why you might want to give your healthcare agent access to medical records. You need to contemplate that when drafting a healthcare power of attorney. And I see people, oh, I've got a healthcare power of attorney, like somebody gave it to me, right, or something, right? And it just is very inadequate. You know, most of the time with power of attorney relationships, that agency ends when you die. So they cease to have any power. Can't access bank accounts, can't make healthcare decisions for someone who's passed away. However, the healthcare power of attorney actually does give you decision-making power over someone after they pass away. And that decision-making power is in the healthcare power of attorney. You can appoint someone that can dispose of your remains, right? And so cremation, burial, those things. And you can direct that, and you can limit that power to say, you know, I must be cremated, right? Or I only want burial, no cremation. That agency power is written into the healthcare power of attorney. And funeral directors have to have that agent, that healthcare power of attorney. I've had him call me up before. Hey, Greg, you know, and ask me, you know, hey, it's got to have this in there, right? Because it's the law for funeral directors that if someone's going to be cremated, unless it's the next of kin, if it's somebody other than the next of kin, right? Like, let's say I pass away and my wife and I pass away and my kids live out of state and maybe they aren't coming in. There's a number of, I've seen these situations. And the person that was appointed the healthcare agent does not have it written in the healthcare power of attorney that they can perform cremation or burial or those things. Then that person's essentially stuck until they can get the the next of kin in town to handle that, right? So if I want to appoint a healthcare agent to handle my affairs during my life, I might want to appoint them to handle burial and other things as well. A lot of times that's the same person you would want to do that. Or they can choose to have an autopsy. They can request autopsies. I would hate to think that you're in a situation where you need an autopsy, but you know, you might want to give someone the ability to perform that duty. Yeah. That's the healthcare agent. So, and we could go deeper down this rabbit hole into mental health decisions. And I think really with a world where Alzheimer's and dementia is more and more, right, being seen as something that has to do with mental health and the mind and those things, right? You know, mental health is really under a separate statute than the healthcare power of attorney, right? 122C in North Carolina. So we want to also expand that healthcare power of attorney to handle all medication and mental health issues as well. So my healthcare agent has the ability, the person I appoint has the ability to manage everything for me. And the reason I go a little deeper down in that rabbit hole is because I want you to understand that these documents are not boilerplate, I printed them off the internet, or I got one from the hospital type of documents, okay? They need to be given more thought. I mean, I'm surprised that hospitals haven't gotten sued to death because of things that have happened with healthcare powers of attorneys that they boilerplate give out to everyone.
Right.
Can a healthcare power of attorney, can the attorney in fact override your living will?
Well, so let's talk about that. So that's a great segue into a living will.
Let's define it.
So a living will. A living will is horribly misnamed by some dumb attorney because it's not about living.
And about your will.
And it ain't no
it's
will.
It's not a will.
Right? I mean, it is a declaration for a desire for a natural death. And it's me stating that, hey, heaven forbid, if I'm terminal, incurable, you know, I've been in a persistent vegetative state, perhaps brain death has occurred. I'm going to say it. Don't ask my wife because she might tell you it already has. I'm not talking about that. But, you know, I'm in a last end-of-life situation. It's my voice in the room. Nobody can hear me. I can't talk. But they can hear me through this document that says, if I'm in this situation, hey, guys, I'm broccoli here. It's okay to let me go, right? I mean, I'm past the point of no return. It's okay to let me go. I have 6 beautiful children, 4 beautiful daughters. They're sweet as pie, most of them. Most of the time.
On any given day.
On any given day, yeah. And I don't know that I want to lay that guilt-ridden decision to pull the plug on dad on their shoulders. So it's a practical document, and it's a legal document that waives liability to my healthcare agent and to the hospital, the doctors, for complying with my wishes if I'm ever in that last-ditch situation, which I hope I never am, but I could be. So that's what a declaration for a desire for a natural death is. That's what a living will is. Brenton, can you expand on that in any way? Or
Yeah, absolutely. You know, I think practically it's important as well because, you know, it's a brutal thought to think of, but hey, you know, if you're on life support, sitting there for a while, man, you can rack up a lot of debt doing that, and a lot of medical debt, a lot of medical bills. And so the longer it's a tough decision to make to let someone go in that state. So it takes a while to make that decision. The longer you take to make that decision, the longer you're racking up hospital bills, right? And if those are unreimbursed medical expenses, they can be applied to your estate and deplete your estate potentially, or be inherited by your spouse.
So what about Hayden's question, which is, should my healthcare agent that I appoint in my healthcare power of attorney be able to override my living will?
Yeah, you know,
And how do we handle that?
That's a personal choice, but you want your documents to speak to each other, and that's what we try to do. You know, we don't try, we do that for our clients. We generally, you know, allow a provision in the healthcare power of attorney that says, hey, you know, if you know, I trust my healthcare agent, there's a reason why I'm naming them, and so I'm going to pick this person to make important decisions for me. And if they determine that, hey, you know, let's wait a couple days before we, you know, turn off the life support, then they have the ability to do so.
Well,
Absolutely, yeah.
what about not just a life-ending situation where you're brain dead? What if you are going to be not necessarily in a vegetative state, but able to do nothing but just lie there for the rest of your life? I mean, can the healthcare power of attorney or living will stipulate that you don't want to be left that way? I mean, is that?
Well, you know, I think we're getting into some. I think that's a different situation.
We can take that up
Right.
with people as if they can ask you, and you can look at their situation.
Yeah, because you kind of what I sense you're asking me is if I'm totally aware and competent.
No, maybe not competent. We're getting in
Yeah.
the weeds. We don't need to do that.
Yeah, I think
that's
I
a
think-
very, very
I think those
specific question.
medical questions as to brain activity and competence and whether you're in a persistent vegetative state and chances of coming out of that, you know.
But neither of these are going to affect the fact that you might be put on a ventilator if you get the coronavirus, right? Because you would be
No.
certainly capable at that time. So.
No. I mean, you know, whatever treatment is necessary, that's a totally different.
Yeah, living
question.
will does not prevent treatment. Yeah.
No.
Absolutely
A living
not.
will would not prevent any treatment. Right. Exactly. And in fact, you know, in the world we live in right now, it would be very important to have in place your health care power of attorney, general durable power of attorney, in case you were, heaven forbid, in that horrible situation, right? So that you have those agents appointed to manage your stuff. So I'm going to take a quick break and talk about just what we're doing here. We're giving a seminar. We're getting ready to get into the last will and testament, which is the fourth and final foundational document we'll talk about. So I'm Greg McIntyre with McIntyre Elder Law. I'm here with Brenton Begley, another elder law attorney here with us. I'm an elder law attorney. We have Hayden Soloway, who has worked with us for years, and we do a number of special events together, and I appreciate her very much for being here today. And I appreciate everyone for listening. And because you've listened today, because you're there, because you're learning with us, we are offering a free consult. We will either see you in our office with an attorney, or we will do a video consult, or we will do a phone consult. Any of those methods, we do those all the time. Before this pandemic, we were doing video and phone consults as well. Every every calendar event on our calendar has the option for a video or phone consult. So we're very, very used to doing that. We are still working in full force during this pandemic. And as a community service, as our civic duty, we are waiving our consultation fees, and we are doing free consults for the public in the areas where we practice, okay? Which is from Charlotte to Asheville, okay, in the western North Carolina area. So if you would like to schedule your free consult, call 704-749-9244. Not only will we waive our consult fee, but also we will give you a free copy of Saving the Farm, a practical guide to the legal maze of aging in America. I worked on the Saving the Farm book for over 2 years, about 2.5 years from researching, writing, and editing. And it is a comprehensive guide to estate planning, long-term care, some of the things we're talking about today, and much, much more. So I'll give you a free copy of Saving the Farm as well. So call 704-749-9244. If you schedule that free consult today, we'll go ahead and give you that free ebook copy or audiobook copy of Saving the Farm, a practical guide to the legal maze of aging in America. Okay? So, back to it. Last will and testament. Brenton, what's a last will and testament?
Yeah, so we're all probably pretty familiar with what the last will and testament is. It is a document that directs what happens to your assets when you pass away. Not only does it direct what happens to your assets when you pass away, but it also names the person who is going to make sure your assets go to the people they're supposed to go to. So that person is your executor. And just like your power of attorney documents, you want to name a trusted individual as your executor to make sure your wishes are carried out. And the other thing is that you might want to have a backup, right? Because anytime that you have someone that you name, you never know what's going to happen in the future. So you want to have a backup there so that you ensure you have someone trusted in place after you passed away to make sure you can carry your wishes out. Now, the will is a great document, and I personally have sentimental ties to the will because I'm a fan of history, and the will has a deep history. Roots come from Greek and Roman history. It's been around for a long time, and I think it's a very important thing to be able to leave a legacy, and the will throughout history is the instrument by which we've been able to do that. Centuries and centuries, right? But I'd ask you, Greg, is the will the most efficient document to pass assets? That's a good question.
It depends on the estate size. It depends on their goals. And those are the things we want to flush out. So a will can be a very dangerous place to pass property for a lot of people. And the reason it can be dangerous is because I know 70% of seniors are going to need some type of long-term care.
Yeah.
Which, if they need that long-term care, could wind them up in a nursing home or assisted living facility, spending down their assets while they're alive, but perhaps keeping the home.
Right.
And then that home can be taken and sold to satisfy a Medicaid lien because Medicaid had to come in and pay for long-term care.
Right.
So what we want to do is try to protect as much money and property as we can for the family, for the individual, for the future, for the kids, for the grandkids, right? For everyone involved. Whatever their goals are, we want to help them achieve that. And a will, in the will process, when we probate the will, we have to publish it in the paper, wait 90 days from that first date of publication. And the reason that's the lien period for liens to come in and attach to the estate. And when we do that, there's a big danger there. You're just kind of waiting on bated breath for liens to attach. There's a proactive duty to notify the Department of Health and Human Services if you're the executor. So you're not going to escape that Medicaid lien. It's not like you're going to get by without them finding out. And if you did, they could open it back up and still try to take it from you. So, but there's ways to avoid all that. So how can we avoid the will but protect assets?
Right, that's a great question. I think we get that question all the time. What we want to do is we want to avoid that probate process where liens can attach to property. There's lots of ways to avoid probate. And if we're talking about the home, especially, there's a very, very, very good way to avoid probate in North Carolina with respect to the home and protect the home. I think, I get the question all the time. What age should I start giving my home away to my children? Should I put my child on my deed, right? Should I give my home away to my daughter, my son?
You can do it, but there's dangers. What are the dangers?
Yeah, first of all, man, you just gave away your home.
You don't own your house anymore.
The house that you worked hard all your life to earn, you paid down a 30-year mortgage, or maybe it was inherited, whatever. You just gave it away.
I have taken calls from people crying. One sticks out in my mind in particular, crying, sobbing, because daughter just kicked her out of the house.
And I've had those too, or can't sell the house, or can't downsize, can't just do what you want with your own home. And it's a tough situation. But
I just don't think that that's the strategy.
I don't think so either.
I don't think that's a strategy at all. I mean, of course, I can give away everything I own. I could do that right now.
Yeah.
But then I wouldn't own it.
That's right. And, in fact, it's a bad strategy because if you give away everything you own, you're making a gift. And, if you were to need to qualify for some type of long-term care benefit, then what you've done is you've triggered a look-back period. And we probably heard about this look-back period, this 3 to 5 year look-back period. And we're mainly talking about Medicaid here, but there's also a look-back period for Veterans Aid and Attendance benefits. And that's a 3-year look-back period. So that means that if you give something away within a 3 to 5 year period, depending on the level of care that you need, man, you've disqualified yourself from receiving that type of benefit, right? A much-needed benefit. And you would have to pay the value of that gift back to a facility before that benefit would pay out. So if you give a home away, home's worth $100,000, guess what? You got a $100,000 bill you have to pay before you can ever get any type of benefit, which is a tough situation to be in.
That's a very tough situation to be in. Absolutely, yeah.
Yeah.
Could it be undone?
It could be, but you have to cure the gift. There's a ton of different ways to do it.
We have a
lot of strategies,
but it's better to do it.
If there's something I like to do, it's problem solve.
Yeah.
Under rule sets, and so we're very good. We have a whole department for Medicaid crisis planning. But if you've gotten to the point where you're in our Medicaid crisis planning department, you've waited too late to plan.
That's right.
Right? That's not planning. That's saying, hey guys, this is the situation we're in. Fix it, please.
Yeah.
What can we protect? What can we do? This is the situation.
Yeah. If you've messed up, we can fix it. But we would much rather you come in and plan ahead, and because there's tools out there for you to plan ahead. And what about the home, Greg? What tool can we use to protect the home, avoid probate, keep the home in your name? I mean, what's the best tool for that?
I like Ladybird deeds for the home. That's one way to protect the home. A Ladybird deed is not even a plan ahead tool. It's a protect the home right now tool. It's an immediate protection of a primary residence and any surrounding property up to a property value of $572,000. That's what a Ladybird deed is. It can save the home and still allow you to qualify for a Medicaid benefit to pay for long-term care, because it's not considered a transfer. It's not considered in the 5-year look-back period for long-term care Medicaid, which pays for nursing home care, or the 3-year look-back period, which pays for assisted living care. So it's an immediate...
So someone already in a nursing home might still be able to do this.
Absolutely, and we don't talk about that enough. If you're in a nursing home, you have a home, and you're on Medicaid to pay for nursing home care, call us. We need to put a Ladybird deed on that house.
We used to get questions like, why do I need Medicaid? I have Medicare and I have
because
Medicare
Medicare
supplement.
doesn't pay for long-term care. Medicare, which every senior over, every person over 65 has Medicare. It doesn't pay for long-term care. You pay for long-term care out of your pocket. That's who pays for long-term care. Or if you have long-term care insurance, which is a small percentage of the population, then long-term care insurance can chip in and help pay. Otherwise, you pay out of your pocket. A Ladybird deed is a great tool to protect the assets, okay? A life estate deed, traditional life estate deed, can also be employed as a plan ahead deed planning method on an infinite number, on any number of properties. The farmland in the upper part of the county, the beach house, those, but we need to get those on the properties outside of the 5-year look-back period. Otherwise, if you're looking to plan ahead, I would ask you to consider trust. And I'd like to finish up with trust. Trust are misunderstood.
Absolutely.
But trust are a great way for you to control your property, your real estate, and your money and investments, but also protect your real estate, your money, your investments. And a revocable trust will give you control over the assets, but no protection when it comes to that long-term care situation with Medicaid, because the government still deems you to own that asset that's in the revocable trust because you're the trustee and you can revoke it. You're the grantor and trustee. But an irrevocable trust, we'll call that, let's say, a Medicaid Asset Protection Trust. It can protect the assets while placing a trusted person, could be a child, a third party, in charge of the home or money that's in that trust. And you can still live off the dividends from the investments in that trust as the grantor. So an irrevocable trust automatically starts the look-back clock ticking on any benefit you would apply for, like assisted living or nursing home Medicaid. But that's a plan ahead tool, and it leaves a lot of flexibility, especially for the real estate inside that trust, which could be rented, sold, anything could be done with that, and still keep the proceeds, the rents, the rents or the proceeds from the sale could be kept inside an account inside that trust, inside that snow globe environment of the trust. That's how I like to think about it. Brenton has written what we call a convertible trust. A convertible trust, and what we've done is we basically bridged the gap between a revocable trust and an irrevocable trust.
That's right.
We bridge that gap with a convertible trust. And we've not only offered control with the revocable trust, but we've offered protection of the irrevocable trust. Brenton, can you tell us in a couple of minutes what a convertible trust is and how our listeners and our clients can benefit from it?
Absolutely. So we want our clients to have the most control possible, especially over their own assets. So what we want them to do is start out with a revocable trust where they have total control. And the benefit of that trust is that they do have total control, and all of their assets will pass outside that probate process if they were to pass away. So they can, control exactly what happens to those assets. They pass immediately to the beneficiaries, avoid probate, and go how the terms of the trust are set up, right? So if you want to hold it in the trust for a number of years, to pay for your grandchildren's education, something like that, you can do that. So that's the revocable trust part. But as you said, Greg, the revocable trust doesn't protect the assets for that long-term care purpose. So what we want to do is give our clients the opportunity to have both control and protection in the future when they need it. So what the convertible trust does is gives you the option at any time to pull the trigger and make the trust irrevocable if you think it's time to do so, because you may have some long-term care need in the immediate future, or if, God forbid, something were to happen to you where you get diagnosed with a debilitating disease, maybe it's dementia, maybe it is some type of, placement in a facility, a long-term care or convalescence facility for a year or more, an indefinite amount of time, then that trust will become irrevocable automatically at that point to protect your assets and to ensure that whatever you put in that trust, those assets that you've worked hard all your life for, become under that protective snow globe type of environment that we're talking about here with the trust.
I think that's amazing. Made a number of recommendations to clients for the convertible trust. Our clients love it. because it gives them the best of both worlds.
That's right.
So if we're willing to plan ahead, a convertible trust can really help us do that. Brenton, I've been listening today. I'm a listener. I'm at home. Hayden has a question.
I wanted you just to
Yes.
work me in. I didn't mean to interrupt you.
No.
There are some questions that we're not going to have time to get through.
I'm just watching the
kind
clock.
The kind of questions that people may want to ask individually, like, will I still own my home and property if I do the Ladybird deed? What control do I have over it? What can and I cannot do with
Sure.
that property?
You can
And-
do anything with that
And what if
property.
I change my mind?
They'll control it.
You can do
And-
anything with that property, and you can change your mind if you have a Ladybird deed on your home. You're
They're
still in
yours.
control of it.
All right.
That's
and
a
if,
great thing about it.
if my children are sued, and they're and I have a Ladybird deeded to them, if they're sued, can that affect them?
No.
Can,
They don't own any interest in the property, so
Okay.
can't go
if I'm
after it.
sued and they're on the Ladybird deed,
Yes.
can that affect me?
If you're
I don't.
sued,
I mean, I don't. That's a consultation type question, I
Yeah.
think. But it's
well, if
something
you're
that I'm actually
if you
curious
name
about.
if you name your children on a Ladybird deed and you are sued, your children are not going to be affected.
Mm-hmm.
They're not going to be personally liable for anything that you would potentially be personally liable for.
Hey, I've got to wrap it up in a second here, and we're going to get toward close. We've got a few minutes left.
One more
and,
question. If someone lives in Manteo or Asheville, can you consult with them?
Oh, absolutely.
Okay. I don't want
Absolutely.
that.
You know,
Murphy to
we
Manio.
will not, from Murphy to Manio, all 100 counties in North Carolina, we would be glad to consult with you.
And we have.
We would be glad to consult with you. There's a number of ways we do that, either in person, video, or telephone consultations, and then we can provide those services anywhere in the state of North Carolina, and we gladly do that. So give us a call, 704-749-9244. Brenton, if I've been listening today and, you know, I've heard this, you know, I've heard about foundational planning, trust, deed protection, you know, I might be interested. How can we take advantage of these types of services? What can we do?
Well, a couple of ways. You can call in and take advantage of the free consultation that we are offering at this time. You know, we also want to give our listeners all the information possible. So we're offering a copy of Saving the Farm. What Saving the Farm is a comprehensive guide to aging in America. So we've taken a lot of time and effort, blood, sweat, and tears, and investing a lot of money in that research to build that guide. So we want to offer that, though, for free to our clients today. We usually charge about $120, or I'm sorry, $20, not $120. It's probably worth $120. But $20
It
per
could be
book.
worth everything you have.
That's right. It could be worth everything you have. And so could a consultation that we usually charge $150 for, but we're waiving that during this pandemic. That is a service that we're providing for our clients at this time. So if you have questions, if you want to talk about any of the things that we talked about today or more, you can sit down with us for an hour by calling in to our office at
704-749-9244. You can get the free Saving the Farm book. That's a $20 value. Feel free to go to Audible, iTunes, get the audiobook copies, get the ebook copies on Kindle. Go to Amazon, order 100 copies to your house at $20 a piece. Or you can get a free copy from our office today by calling 704-749-9244. And we'll waive our $150 general consultation fee that we're offering as a civic duty during this pandemic with our office, either in-person video conference or telephone conference, to get your affairs in order. It's about time, don't you think? Hey,
Right.
Please don't wait till it's too late. Call McIntyre Elder Law. And Milton, how are we doing on time today?
Well, we just have about 30 seconds.
30 seconds. I wanted to thank everybody for listening today. Thank you, Hayden Soloway, for being here today and asking
My
questions
pleasure.
and being
You know
our
that.
audience. Thank you, Brenton, for everything that you do in our office. And thank you, everybody in my family and that know me, for putting up with me. So besides that, it's my mission and it's our mission to help clients, protect clients, and put out great information to the community. Tune in next week, same bat time, same bat channel, where we'll be on talking about a new and exciting topic relevant to the time and day. And I can't tell you what that is because times they are a changing. That should be the song we play out on, Milton. Little Bob Dylan.
Bob Dylan for you.
We'll have to prepare that one for next
That's
time.
right. Thank you, Milton. Thanks for engineering for us today. Have a great day, guys.